gun owners should not be forced to ride in the back of the bus or denied access to lunch counters, the way that certain southern states did to African Americans in the Jim Crow South. And yet, in my view, that is what states like New York intend to do as revenge for the Supreme Court's decision in NYSERPA versus Bruen. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, best-selling author, and yes, member of the United States Supreme Court Bar. If you have not already subscribed to the Four Boxes Diner, please do so and show your love for the Second Amendment's right to keep and bear arms. If you've been watching this channel since its beginning about 6 or 7 months ago, you will know my fear and my warning to everyone who would listen about how the concept of sensitive places, which are euphemisms for gun-free zones, will be how the anti-gunners will respond to a tremendous victory in favor of the Second Amendment and gun owners in NYSERPA versus Bruen. And just as I predicted, and just as the people on this channel watched and learned many months ago, that is exactly what is about to happen. I don't think it's going to work, and we're going to talk about both right here. Remember, on this channel, I just don't want to give you a headache about problems and issues that I spot in the anti-gunner community. Part of my goal is also to give you the aspirin to solve the problem of the headache. And I'm going to do both in this video with what I think New York is really trying to do with these so-called sensitive places. You see, what's just happened is the New York governor and the New York state legislature are going crazy about having to honor the U.S. Constitution as it's written. So they're trying to get around it. And one of the big ways they're trying to get around it is, as I predicted, to try to declare as much of New York State as a sensitive place, gun-free zone as possible, under an exception to the rule that you get the right to carry guns everywhere in the United States, except sensitive places. But I don't think it's going to work. Now, the way New York is doing this is very creative on their part, but it's probably completely unconstitutional and illegal. The way they're doing it is this. One aspect of the law they're talking about is passing a law that says this: nobody with a concealed carry permit will be allowed into any business establishment, whether it be a restaurant, an ice cream parlor, a bar, a tavern, a store. If it's a business in New York State, you name it, you will not be allowed in with your concealed carry gun and carry permit unless, and this is the key, unless the owner of the property, the owner of the business puts up a big sign that says concealed carry guns are welcome, or concealed weapons are allowed. In other words, what New York is doing is they're flipping American law on its head. Traditionally, respect for property rights would say you have the right to decide who comes on your property or not, including businesses. You don't want to let somebody in because they misbehave or whatever. You can, generally speaking, keep them out because, say, hey, I'm not letting you in. Of course, that's been whittled away over the years, and we'll talk about that in just a second. So what's here, so you have places like in Texas that say you can carry firearms in public places unless someone posts no guns allowed in a very particular bold setup. That's the reverse of what New York is doing. New York is doing it in reverse. They're saying that no one is allowed to bring a gun onto a business unless the business owner expresses the willingness and desire and acceptability of letting concealed carry weapons onto the premises. They flipped American law on its head, and it's illegal. So first of all, it's illegal under, in my view, the NYSERPA versus Bruen case. Because remember, what NYSERPA versus Bruen says is that a government cannot regulate a conduct that falls within the text of the Second Amendment. Now, the text of the Second Amendment says the right of the people to keep and bear arms shall not be infringed. To bear arms includes, obviously, the right to carry guns. That's what the Supreme Court just held. So the question is whether or not there's any historical analogs or precedents that New York can point to at the time of our founding in 1791 or so that would allow the banning of firearms in private premises by a government statute or regulation. This is what the Supreme Court wrote, and I don't think New York could possibly meet the standard, which is the Supreme Court standard for the Second Amendment. The Supreme Court in Clarence Thomas wrote, quote, "When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects the conduct. The government, in this case it would be New York State, the government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation." That is the burden of proof to justify this law. The burden of proof lies with the state of New York to show a historical analog, a historical example at the time of the founding to show that this kind of regulation saying you can't bring a gun with a concealed carry permit into a private business unless they specifically say concealed carry weapons are allowed on this premises. I don't think they're going to be able to justify that under the Second Amendment, under the Supreme Court precedent. I think it will fail for that reason alone. But that's not the only reason why it's going to think. And I'm going to give you many reasons because, again, I don't want to just give you a headache. A lot of people say, oh my God, anti-gunners are doing bad things. Of course they're doing bad things. That's what they do. But the harder job, the more important job as I see it, is to try to provide aspirin, to try to provide proposed solutions or responses to defeat the efforts of the anti-gunners to take away our rights. And that's what I try to do on this channel. Give suggestions and ideas for people to reflect on and maybe do something with if it makes sense to do so in the context in which they're, doing whatever it is they're doing, talking about in the press or writing op-eds, whatever it happens to be. So here's the other reason why, by the way, I think this doesn't work. Think about this from the context of the property owner. Set aside the fact that New York doesn't actually give a crap about property, right? They said, this is actually what Kathy Hochul, the governor, said. She said she wanted to let property owners decide who has firearms and who doesn't. She wanted to respect property owners. We know that New York doesn't care about property owners, right? This is the same state that required nursing homes. Last I checked, nursing homes are a business. Nursing homes were required by the government to take people with COVID back into their nursing homes. Remember that controversy? So where was the respect for the owners of the nursing homes in not requiring them to take people that had COVID back into the nursing homes? Some respect for private property. And we know New York is one of the highest tax states in the country. It has massive regulations. It's impossible to evict tenants even if they don't pay their bills, and so on and so on and so on. New York doesn't care at all about private property as best I can tell. So the suggestion that we're going to care about private property all of a sudden when it comes to the Second Amendment, a fundamental right, is simply, in my view, absurd. But let's go beyond that. It's also illegal from the point of view of the property owner. Here's why. There's a long-standing law under the Constitution, right, and the Supreme Court's interpretation of the First Amendment. We all know what the First Amendment is about. The First Amendment protects several rights. One of the rights is the right to free speech. Now, the right to free speech actually has two components. People don't always understand this. The right to free speech you have the right to speak out, to express your opinion, to talk about issues. Thus, you have the affirmative right to say things, to speak, to write, to text, to use the internet, to stand on a soapbox and speak. That's the affirmative right of the right to free speech. But there's another component of that right. You also cannot be compelled to say things you don't agree with. Again, compelled speech by the government, unless it's just purely factual information about like a product or service in the commercial context, is not legally allowed under the First Amendment. There's multiple cases. There's a case called Woolley versus Maynard in the state of New Hampshire. The state of New Hampshire has license plates to say on the bottom, live free or die. That's a statement I generally agree with. I like it. But not everyone did. So in the case of Woolley versus Maynard, this is many decades ago, the Supreme Court says, look, if you don't agree with the concept of live free or die, then you don't have to drive around with that license plate. You are allowed to put tape or something over to block off the message because the state of New Hampshire, as a government agency, cannot compel you under the First Amendment to embrace that concept. And also there's other examples of this. There was a case that back in 2018, just to give you the site, National Institute of Family and Life Advocates versus California, or Becerra. In this case, basically, the state of California was trying to require anti-abortion organizations or companies and businesses that were trying to discourage abortion from putting pro-abortion messaging into their businesses and their establishments. And the Supreme Court says, no, the state of California cannot force organizations that disagree with abortions to put pro-abortion messaging in their place of business, their establishments, because that would be compelled speech illegal under the First Amendment. So as I see it, forcing businesses to affirmatively put up a sign that says concealed weapons welcome here or something like that would be compelled speech, because the only way I would be able to let people exercise their Second Amendment rights in my store, in my business, in my office, is if I declared a public position on a political issue, a constitutional issue, a social issue. And it seems to me that that is compelled speech and would be violative of the First Amendment, would be struck down from the point of view of the business owners in the context of trying to discourage gun owners and concealed carry in the state of New York. But beyond that, let's just think about how stupid this is. I want to talk about the policy for the moment. Just how dumb is this? Well, New York State is worried about people bringing guns into businesses, but they don't care who the people are. We know statistically, and I'll put the links down below, we've talked about this many times on this channel, the data bears this out over and over and over again, people that willing to go through the process of getting a concealed carry permit are more law-abiding statistically than even police officers. They're basically the most law-abiding cohort in America. Far more law-abiding than ordinary Americans, and far more law-abiding, again, than even police officers and law enforcement officials. So why is it that the state of New York is trying to say that these lawful people are not allowed to bring their guns under the Second Amendment into these businesses? But guess who the state of New York does allow to come into these businesses? Well, set aside the obvious of all those shoplifters we see on the film where they go into these New York businesses and steal everything out and no one stops them. Cops aren't there. No one seems to be arresting these people. They seem to be just shoplifting every day. But beyond that, let's just say you're a 3 or 4 time violent felon. Nothing prevents you from walking into any of these places under New York law with a baseball bat, with a knife, or just with your fists in hands, and you can beat people up. No interest in that. In fact, New York policy, I would argue, actually encourages violent felons to be able to go into these businesses for many reasons. And here I think is the best example of this. As a general matter, and I'm reading from, I'll put the websites down below. As a general matter, and this is a New York City website talking about New York law. It's a New York-based website, at least. The city, that's the New York City, the New York City human rights law makes it illegal for most employers in New York City to ask about the criminal record of job applicants before making a job offer. This means job postings, applications, and interview questions cannot include inquiries into an applicant's criminal record. So these same businesses that Kathy Hochul, the governor of New York, is worried about protecting their rights of who comes into their establishment under New York law, these people are banned from asking questions about who goes to work for them involving criminal records. So they're willing to say, come on in if you have a felony record. Come on in if you're a criminal that went to prison. But if you're a law-abiding gun owner in the cohort of the most law-abiding people in America, based on the data, you're not allowed in with your firearm under the Second Amendment. That, to me, is hypocrisy, and I don't think the courts are ultimately going to allow this to stand. To wrap up, New York is trying to create a policy to take advantage of the so-called sensitive places or gun-free zone exemption. But it's not going to be constitutionally allowed as I see it. Because remember, as Bruen points out, the only places that are constitutionally sensitive places or gun-free zones that the government can carve out are really government facilities. They specifically mention polling places. That's a government function. Legislative assemblies like the U.S. Capitol. That's a government function, passing laws. Courthouses. That's a government function of administering justice. And schools, which again are public schools. That's a government function as well. So it seems to me what New York State is trying to do in defining all these things as sensitive places and now trying to call every business a sensitive place unless the business owner specifically invites in people with firearms, which I think violates the First Amendment, that is probably unconstitutional under the Second and the First Amendment, and it's terrible, stupid public policy as I see it. Okay, so I hope you learned something here at the Four Boxes Diner. We'll see you again soon. Four Boxes Diner. If you haven't subscribed, please do so. See you again soon.
Orders up. Table 2A.